Welcome to this week's episode of Ask an Atheist. I am Andrew Seidel, the Director of Strategic Response here at the Freedom from Religion Foundation.
And I'm Patrick Elliott, Senior Counsel and Litigation Counsel for FFRF.
And I'm Rebecca Markert, the Legal Director at the Freedom from Religion Foundation.
So today we are going to be talking about the rarest of 2020 beasts, good news. The Supreme Court did the right thing and LGBTQ equality took a giant step forward this week. As always, if you have questions or comments about today's show, feel free to leave them right there in the comments on Facebook, or you can email them to askanatheist@ffrf.org. And you've got three attorneys here today, so now's a good time to ask.
And we're going to be talking about a U.S. Supreme Court decision that was over 150 pages, and we're lawyers and we like quotes. So our show today is going to be text heavy. So if you want, you might want to expand your browser so you can see some of the graphics that we provide. So the case that we're all so happy about is Bostock versus Clayton County, Georgia. That was really three cases from three different circuits brought by three different people: Gerald Bostock, Donald Zarda, and Amy Steffens. Bostock and Zarda were fired for being gay, Steffens for being a transgender woman. Both Zarda and Miss Steffens died while the cases were winding their way through the courts, but we all owe these three brave citizens a debt of gratitude.
True champions, American heroes and heroines. Now, we all know that discrimination is bad, but bad is not the same thing as illegal. And this is actually a pretty simple case and not that hard to understand once it is explained to you. So that's what we're going to do today. And sex is at the heart of the matter. So Patrick, start breaking this down for us.
Right. It's a pretty simple case. Particularly if you read what Justice Gorsuch, who wrote the majority opinion about this, and in one paragraph, he really explained, what this case is about and what Title VII and sex discrimination is about. And so Gorsuch said, in Title VII, Congress outlawed discrimination in the workplace on the basis of race, color, religion, sex, or national origin. Today, we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and an indisguisable role in the decision, exactly what Title VII forbids. So I think that does a pretty good job of laying out, where this opinion goes and how the court treated it. They treated it as a simple decision. Obviously, in the larger public, it seems like a much more complicated issue, and people have obviously been fighting for this for many decades. But as the way the court treated it, they treat it as a straightforward kind of statutory interpretation.
Yeah, and that's really a remarkable paragraph. It is so clear what the court was deciding here. And it was remarkably clear for any legal opinion. So I think that was one reason we wanted to highlight that. And it's one reason that we're actually highlighting quite a few of the quotes from the decision, because it's so clear and so concisely written. So the law is clear. You can't discriminate based on sex. But Gorsuch says that the answer is clear too. And Rebecca, he gave yet another clear and helpful paragraph. This one, an example. Can you explain that example that he gave for us?
Yeah, he did really make this simple. And actually, when I was reading the decision through all of these examples, I kept thinking, the answer is so clear and simple. I wonder why it took us so long to get here. Basically, he's saying that firing someone because they are LGBTQ is necessarily a decision made because of their sex. The example that he uses is this. Consider, for example, an employer with two employees, both of whom are attracted to men. The two individuals are, to the employer's mind, materially identical in all respects, except that one is a man and the other a woman. If the employer fires the male employee for no reason other than the fact that he is attracted to men, the employer discriminates against him for traits or actions it tolerates in his female colleague. To put another way, the employer is only firing the gay man because he's a man and happens to like men. The employee would be fine with a woman liking man. So sex is at the center of the firing decision.
And Gorsuch gives another example. I think the examples in the opinion are helpful in a way because in the term sex, it's hard to necessarily get to, gender identity discrimination or, LGBTQ discrimination more generally. And so one of the other, I guess, examples that he talks through is, how are people treated differently? And so Gorsuch says, or take an employer who fires a transgender person who identified as a male at birth, but who now identifies as a female. If the employer retains an otherwise identical employee who was identified as female at birth, the employer intentionally penalizes a person identified as male at birth for traits or actions that it tolerates in an employee identified as female at birth. Again, the individual employee's sex plays an unmistakable and impermissible role in the discharge decision. And I think, I think that helps make real this how we get to sex discrimination, and how when you look at it from that perspective, his decision makes sense. Obviously, courts for a number of years haven't found this same reasoning persuasive, but I certainly think it's persuasive.
I think so too, and I really like both of those examples. I think they do draw out what the issue here is. And there's an older Supreme Court case, Price Waterhouse versus Hopkins, that may also be a little bit helpful in understanding this. So there, Amy Hopkins was denied a promotion because the company thought she needed to, quote, walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, wear jewelry.
Right, and that case is a mixed bag, but the analogy is useful. Hopkins was denied equal treatment because she didn't fit a stereotypical and sexist view of how a woman should behave. But all the men in the office were as aggressive and demanding as she was. Same traits, but men were rewarded for having them, and she was punished for having them. This week, the court used that logic to apply to sexual attraction and gender.
Yeah, and so we have kind of how, again, Justice Gorsuch summing it all up, and he wrote, an individual's homosexuality or transgender status is not relevant to employment decision. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against an individual based on sex.
Yeah, I really thought that was excellently written. And the reactions to this case too have been really pretty amazing. I mean, The Nation had this great headline, Neil Gorsuch stuns the nation, does the right thing. I loved that, but that was probably the one from our side that was pretty good. The National Review had one here, The Emperor's New Law, Magical Thinking Replaces Jurisprudence at the Supreme Court. I don't think we got the American Conservative, but they talked about, they had a headline about fear-mongering about Pandora's box. And then my favorite, Christian nationalist bigot Brian Fisher, who is affiliated with the American Family Association and hosts a radio show for them, he just lost it. I mean, this is one of his tweets talking about carpet bombed daily by the cultural Luftwaffe of the left. And then let's take a look at the next one there, Bruce, of his, where he says, Trump's judges jumped right over homosexuals and lesbians, which that itself is a pretty ignorant phrase, and gave special rights to fake men and fake women, also ignorant and bigoted. May God help us. But this is hilarious to me because it's very clear that he did not read the opinion. I mean, right? This applies to both homosexuals and transgender. Like it's a big, broad victory. Oh,
right. Well, the reaction shows, I guess pertinent to us, how much religion is tied up in this issue. Yeah. You could read this and there's a very slight discussion of religion, but it was a part of these cases, the underlying cases and the underlying why people are being treated this way. In particular, in the Amy Stevens case with the funeral home, the owner basically said outright that it was because of his religion and his belief in God and how people are to dress and act. And so I think maybe that's why we're seeing that reaction from the religious right is this is big news to them. And it's certainly, signaling something about kind of where that a conservative justice, which Justice Gorsuch is, could write this decision was kind of a shock.
They were laughing. Go ahead, Rebecca. No, go ahead.
I was just laughing when you said it's clear that he didn't read the opinion, just because there are a lot of evangelicals and Christians who haven't read the Bible either. So it's kind of funny.
Well done. Yeah, I mean, And to me, we'll get into the religion in a minute, but let's talk for a second about the dissents, because given how clear this is and how consistent the decision is with the text of the Civil Rights Act, how did we get dissents from Alito and Kavanaugh, joined by Thomas, that were 4 times longer than the majority opinion? I mean, what are these three really complaining about here?
Yeah, they were really mad, Alito particularly. But really, there are 2 dissents, one written by Alito, joined by Thomas, and then Kavanaugh's dissent. At the first reading, they're actually very similar arguments. Both of the dissents agree that expanding Title VII was actually a role for Congress and not for the courts to do. But how they got to that conclusion was slightly different. Alito's arguing that the court needed to look at the way sex was defined in 1964 and how Congress in 1964 defined sex. Kavanaugh boiled it down to a separation of powers issue. He argued Congress and the president were the ones who could expand the statute to include sexual orientation and gender identity. They didn't do that in 1964, and they haven't expanded it since then, despite many, many attempts to do so.
And, Alito, he called the majority opinion brazen, which I thought, is kind of unbecoming of a justice. But he dedicates a significant amount of space, and this is what pained me in reading the decision, into the definition of sex in dictionaries from 1964. So we're all doing a favor for everybody by trying to sum this up, and so that you don't have to read this. And as Andrew referenced, I think there was, maybe more than 170 pages of material, but 50 plus pages of that were just an appendix that Alito attached, including some of those dictionary definitions. But to really get at what he was saying, we do have a quote, and I think we've had it up there. He says, the court tries to convince readers that it is merely enforcing the terms of the statute, but that is preposterous. Even as understood today, the concept of discrimination based on sex is different from discrimination because of sexual orientation or gender identity. And in any event, our duty is to interpret statutory terms to mean what they conveyed to reasonable people at the time they were written. If every single living American had been surveyed in 1964, it would have been hard to find any who thought that discrimination because of sex meant discrimination because of sexual orientation, not to mention gender identity, a concept that was essentially unknown at the time. And he does continue and says, many will applaud today's decision because they agree on policy grounds with the court's updating of Title VII. But the question in these cases is not whether discrimination because of sexual orientation or gender identity should be outlawed. The question is whether Congress did that in 1964. So it's really a kind of a historic test. Let's look at just 1964, see what sex meant then, specific to that word, which does differ from how the approach Kavanaugh takes in the next dissent. But that's really the approach that Alito spends many, many pages and many, many rebuttal arguments to what the majority opinion says. So it's quite onerous in going through it, but we tried to kind of give a general summary of the dissent. Kavanaugh, his dissent, I think one thing that's telling about it is how much I would say the religious right has lost the culture war on this issue because, in terms of discrimination against LGBT Americans. So Kavanaugh's dissent, he even calls it really a victory. And so we've got a quote, notwithstanding my concern about the court's transgression of the Constitution's separation of powers, it is appropriate to acknowledge the important victory achieved today by gay and lesbian Americans. Millions of gay and lesbian Americans have worked hard for many decades to achieve equal treatment in fact and in law. They've exhibited extraordinary vision, tenacity, and grit, battling often steep odds in the legislative and judicial arenas, not to mention in the daily lives. They have advanced powerful policy arguments and can take pride in today's results. Under the Constitution's separation of powers, however, I believe that it was Congress's role, not this court's, to amend Title VII.
I have to say it's still so jarring to see his face and think of him as a Supreme Court justice after his performance during. Anyway, and the thing that I loathe about his opinions, and we saw this in some of his state church opinions as a D.C. Circuit Court judge too, and I think that paragraph in particular is just so patronizing. You guys are doing such a great job. You're fighting. I really admire what you're doing. And then stabs everybody right in the back with the actual content of the case. He's just very fluent in that. And it makes it more insidious than Alito, I think, who's just clearly about to pop a blood vessel in his brain because he's so angry. But this is still, I mean, this is a huge deal. I mean, certainly it is the biggest win that trans Americans have seen at the Supreme Court, and it's huge. It's hard to overstate really how big this is for LGBTQ equality. But it's not all good news. There is a big but written into this decision, right, Rebecca?
Yeah, and unfortunately, as lawyers, we're always looking for that but and waiting for what this means for the future. The court in this case failed to address a critical question, one that is really important to FFRF. Can Christian employers claim a religious right to fire LGBTQ employees? And those cases are already in the pipeline. Here's how Gorsuch wrote about it. We are also deeply concerned with preserving the promise of the free exercise of religion enshrined in our Constitution. That guarantee lies at the heart of our pluralistic society. But worries about how Title VII may intersect with religious liberties are nothing new. They even predate the statute's passage. But how these doctrines protecting religious liberty interact with Title VII are questions for future cases.
Yeah, so this is a big but, and it's the fight that we have coming, and I think it's why what FFRF does, fighting for state-church separation, fighting to end the weaponization of religious liberty, is so important. I mean, we've been fighting this battle for, at least a decade now. And I think all of us are pretty alarmed about it. Let's get into a little bit of the specifics before we get to some of the questions. I mean, there are basically three ways, right, that these cases, the religious freedom argument could end up at the Supreme Court. You've got the First Amendment, free exercise of religion. We've got the Religious Freedom Restoration Act, which the court mentioned, and then those ministerial exceptions, and which there's also one of those in 702A of the Civil Rights Act. So do you guys want to dive into any of those specifically? Any other things you want to hit on before we get to the questions on this?
Well, just on the RFRA point, that was an aspect in the funeral home case here.
Yeah.
That was something that they were asserting, and they actually lost at the lower court. So that's why the Supreme Court didn't address it. So there may be other courts that are going to have to address whether an employer's religion could mean that they could discriminate against an employee, which we certainly think would be wrong under this decision. But that's why the court didn't get to it, is because the lower court actually ruled correctly on that issue. So it was actually a part of one of these cases.
Yeah, I mean, and that
Gorsuch
case
mentions that. Oh, sorry. I was just going to say.
No, go ahead, Rebecca. Yeah.
He mentions it in his opinion that they had lost at the lower level and abandoned that appeal, so it wasn't a question before them. But he also mentioned that RFRA is this super statute that supersedes things like Title VII. So when I was reading that, I was really thinking, is he giving them a roadmap? Like, why don't you bring that back up again? And I think we're going to see that.
Yes, I agree. And I mean, I remember, so the Hobby Lobby case was a RFRA decision, and the Amy Stevens' case, the funeral home case, was the first case after Hobby Lobby. And so I remember watching that and commenting on it at the time. I think I wrote a blog for FFRF and being really concerned about how it was going to go and being really relieved when the religious question was not appealed. So, I mean, I think it is crucial for everybody to understand that this issue is coming back to the court, and it's coming back to the court very, very soon. And it could be under any one of those different guises. This is the next fight. I also think it's important that everybody knows that all of the fear mongering that you're seeing around about how the court struck a blow at religious liberty and religious freedom. First of all, that would be nonsense if the court actually addressed the issue. But it's nonsense because the court didn't address the issue. They specifically punted on it for a later date. And now, well, while we're talking about cases that are going to come before the Supreme Court, and since we're on this big but, we should let people know that the term is not over, right? That the court is handing down more decisions, including on some very big cases that we've been watching, that we have been submitting briefs in. Excuse me, as I choke over here. And we could actually see some of those cases come down tomorrow. So the court hands down decisions tomorrow on Thursday, and then again on Monday, and on the Monday after that. So what cases are we watching?
Right. So we're likely to have a bad decision, at least one of these cases. So I just give that warning as we should, celebrate now, but there may be some serious harm from the Supreme Court coming our way. And one of those cases is Espinoza versus Montana Department of Revenue, where the court's going to decide whether the Montana Supreme Court's decision that the state was prohibiting funding to religious voucher schools, whether that violates the free exercise clause of the U.S. Constitution. And so that's a big case that not just for Montana, but many states would be watching that to ensure that their money's not spent, to indoctrinate religion. One of the other cases we're watching is Our Lady of Guadalupe versus Mercy Buru, which is about whether religious schools may be completely exempt themselves from civil rights laws if they seek to classify their teachers as, quote, ministers, or fall under this ministerial exception in the law, which typically is applied to ministers of churches and not all employees of an organization. So those are two, and Rebecca has two more that we are kind of keeping our eye on.
Yeah, two other cases that we submitted or signed on to amicus briefs for. One is June Medical Services versus Rousseau. This is the case that involves the Louisiana law requiring doctors who perform abortions to have admitting privileges at nearby hospitals. This one was a concerning case because they had just decided a similar law was unconstitutional in Texas. The only thing that's changed in between that case and this case is the makeup of the court. So we're concerned about that one as well. And then the final one is Trump versus Pennsylvania, involving yet another challenge to the ACA's contraceptive coverage mandate.
Yeah, huge cases. And, I think some of those have gotten lost in the discussion of the court this term because, there's still the DACA case outstanding. There's Trump tax return cases outstanding. But really the one that I'm most worried about is that Espinoza case that Patrick mentioned, though all of them could be just body blows to state church separation. So stay tuned for that. Now, we've got a ton of questions rolling in, and I'm going to ask, we've got one that we were just talking about, RFRA, the Religious Freedom Restoration Act, being a super statute. So KL asks, the majority opinion mentions the super statute RFRA and that it may take priority over Title VII. What can we do to make sure that RFRA is not invoked as a legal justification for this kind of discrimination?
The biggest thing is advocate for its repeal, right?
Yeah. And that's something that FFRF has been doing for a long time, since before the Hobby Lobby decision. We actually are pretty confident that the Religious Freedom Restoration Act is unconstitutional because it is a super statute, which is not something that Congress can pass. But another thing that we could do, too, in addition to just repealing RFRA, is we could pass the Equality Act, which specifically says that RFRA doesn't apply to things like the Civil Rights Act and doesn't allow, essentially, discrimination in the name of religion. So that's another thing that we could do there. Lewis asks, what is the significance of this being a 6-3 decision rather than a more closely divided 5-4 decision? And can that tell us anything about what to expect in those other highly anticipated civil rights cases that we were just talking about?
One thing it signals, which we've known, is that Justice Roberts very much cares about precedent, or as lawyers would say, stare decisis. So that may bode well for the case like June Medical on abortion admitting privileges, because he would be likely to side, I think, with the liberal justices in that. The reality is a 6-3 has the same force as a 5-4. I think also with the Roberts Court, they're trying to not be as divided. And so I think they're striving to have unanimous opinions, which have happened, or more clearly 6-3 or 7-2 versus these year after year of having very closely divided 5 conservatives versus 4 liberals. So in terms of the cases coming up, it signals that there might be a coalition that would benefit our issues, state church issues, because of how Roberts treats these. Gorsuch, we have no idea, obviously, how he would rule on some of these other cases, and he may well, retreat back to the conservative side on some of these other cases.
Yeah, I feel that it has no bearing on how the future cases will be decided. I think that it's very likely that we see Gorsuch retreat back to the conservative side. Roberts has been the one who's been the swing vote since he became Chief Justice. He's the one who has made some really good decisions and some really bad decisions. So I think it's hard to say whether it being 6-3 this time is really significant.
Yeah, I'd agree with that too. And I think, Roberts being in the majority gets to decide who writes the opinion. So him being in the 6 is he assigned Gorsuch the majority opinion, which I think is probably significant. I also think that if this had been the religion issue, the religious freedom issue that they punted on, the case would come out completely differently. You'd see a completely different lineup. And had Roberts not joined the 5, making it 6, Ruth Bader Ginsburg would have gotten to decide who wrote that opinion. So it could have also been a very different opinion, and perhaps even more wide-reaching. So those are some other fun things to think about, even though there's no real way to know anything. Okay. Brian Cull says, does Alito really believe that these issues of gender identity, et cetera, did not exist in 1964?
Just reading it, I think he's getting at, he's not saying that they didn't exist. He was looking at both how the term, sex was being used and with these dictionary definitions, which I found very laborious to review, but also the issues at the time. I think he's tapping into, and we've seen this in other opinions, which is frustrating, these history arguments, which were, what was the movement behind this? What was the legislative intent? How would people at the time would they consider sex discrimination inclusive of, gender identity, and discrimination based on being gay or lesbian? So I think that's more so what he's getting at. Some of the bad history that's actually in some of his opinion, talks about that, that basically being gay or lesbian was viewed under the DSM as a mental disorder up until the 1970s. And he cites and talks about that. So I think he kind of has this historic approach, which is, let's just take a time machine to 1964. So I think he's not saying that some of these issues weren't there, but he seems to be saying, hey, this law wasn't intended to cover this. And I think Gorsuch and people have good responses to that, which is all the time we pass laws that we can't necessarily know all of the circumstances that they might encompass. And so that's kind of the answer, I think, is obviously this should be covered by that, even if it wasn't the direct or primary motivation for passing the law in the first place. And one of the examples is men. Men are covered under sex discrimination, and that probably wasn't, or at least in the legislative history, wasn't a motivating factor, because heavily it was women that were being discriminated against in employment. So that was an analogy that Gorsuch used to talk about, why this should have a broader interpretation.
Becky, you want to add to that at all?
I think he was also looking at like Patrick said, the history of it all, and the fact that a lot of laws really made homosexual activity and just being gay illegal. And so therefore, this section of the law couldn't have applied to that, because we had all this body of law that already made that stuff illegal, just to be. I think Patrick covered it pretty well.
Yeah. It's so frustrating to read the opinion, because to me, the dissents that Alito and Kavanaugh wrote, because to me, they're just missing the argument in its entirety. Discriminating against somebody because of their sexual orientation necessarily means you're discriminating against them because of their sex. You think that men should only like women, and therefore you're discriminating against a man who likes a man because they are a man. It's so... I would really encourage everybody to actually go read the majority opinion. I think it's remarkably clear, and I don't think you have to be a lawyer to understand it. Anyway, back to the questions. So we have a couple questions about federal regulations. I'm gonna lump them together. So one, Chris asks, do you think this is really a step forward, given that HHS passed that rule last Friday, saying that it would no longer recognize anti-LGBTQ discrimination as sex discrimination? And then Lindsay ask, what impact does this have on federal agency rules that permit discrimination? So pretty similar questions there. Have at it.
Well, we were talking before the show that you probably are the better person to speak to this, but obviously it's going to have a big impact on whether those rules are able to go forward and whether they're constitutional.
Yeah, I'm going to say something nice about Alito's dissent actually right now. He very helpfully provided a list of all the federal statutes in his appendix that talk about sex, that this ruling should theoretically influence the interpretation of. I do think this is going to have a big impact on those regs. I think it's going to cause them to have to rewrite a lot of them. They were based on rationales that were more in the Kavanaugh-Alito dissents than were in the majority. And that understanding doesn't hold up anymore. So we'll see how that ends up shaking out. But yes, I think there is a lot that we can do in terms of stopping some of those bad rules from taking effect now. All right. And I am not seeing any more questions. Everybody's just off celebrating this awesome ruling. So that's good news. Is there anything else either of you want to add other than fingers crossed? As all of, we're super superstitious over here. So fingers crossed for tomorrow.
The only thing I would add is that this week, I think, Andrew, you got one too. We got these masks from the Secular Coalition for America for Pride Month. And I was just so happy that we got it pretty much on the same day or the same week that the ruling came down. So when I've been wearing this out and about, everybody's complimenting it, and really happy. So I feel very celebratory when I'm wearing this now.
Me too. I've gotten quite a few compliments on it. And we actually do have one more question that I think is really worth us talking about. So we're going to back up and before we close out. Nicole asks, hi, Nicole. It's Nicole Niebler, our good friend and plaintiff. Since it's not federally illegal to discriminate for LGBTQ reasons, can people sue churches for not hiring women, trans folks, gay folks, etc., as priests? So that's going to be our last question. So, I mean, this really gets the ministerial exception, the Hosanna Tabor, and then that 702 exception in the Civil Rights Act too. But go ahead, Patrick or Rebecca.
Right. Just generally the courts, even just as a judicially created construct, besides just the actual Civil Rights Act having a loophole for kind of church employees, the courts have said they're not going to weigh in and basically tell religious organizations who is and who isn't a minister. And so that's the subject of actually an ongoing case the Supreme Court's going to rule on in relation to school teachers. So really it's an area where what we know is people teaching the faith are very likely going to not be covered, by this ruling. But there may be some religious affiliated organizations, obviously Catholic hospitals, that hire people that aren't fulfilling a religious role that would be covered. So there's a benefit, obviously, but the exact line between churches hiring people and religious affiliated organizations is something that I think is going to be probably worked out still in future cases.
Rebecca, you want to add anything to that?
I have nothing to add. I think he covered that pretty well.
Yeah, I think so too. I mean, it makes a certain amount of sense. If a church wants to hire a bigoted priest, then that's part of their religion. That's permitted under the First Amendment. It's protected under the First Amendment. So the court's not going to step in. But the question is, what about when the church also runs a school and we're talking about a custodian or somebody who's teaching math or coaching the basketball team? That's not particularly a religious or not clearly a minister. Where does the line get drawn? So those are some of the cases that we're going to see. And we're going to be keeping an eye out for all of those at the Freedom From Religion Foundation and making sure that you understand the cases and the court does the right thing to the extent that we are able to force them to. So that is our show, Ask an Atheist, for this week. Thank you so much for joining us. If you want to support the work of the Freedom From Religion Foundation and make sure that this big, giant step towards equality is not accompanied by 2 steps back in the name of religious freedom, join the Freedom From Religion Foundation and support our work by visiting ffrf.org. We will be back next Wednesday at noon Central Time with another episode of FFRF's Ask an Atheist.